and given my ruling that the state would not be permitted to make arguments that Mr. Miu's experiences should be discounted because there's no evidence of a medical provider, a psychiatrist, psychologist, or prescription medication because they had objected to that evidence. So that's my summary. If anybody wants to add to it, you may do so.
That's my recollection, Judge.
Yes, Judge, just to make it clear, I wanted to, as an offer of proof, I wanted to ask Nicolae about how his body responded to those nightmares. That is, when he woke up, what was his body feeling? Was he chills? Did he have sweat? Was he shaking? If I had asked those questions, I would anticipate that he would have told me all of those things would have existed. I again think that that would further support his claim that the nightmares were real. Secondly, I wanted to ask him about the treatment, and I expected him to testify that yes, he saw a doctor and a nurse, mostly a nurse in the jail, and that he received a prescription for prazosin, which it's his understanding and confirmed by my research that that is a prescription for PTSD-related nightmares. And so again, as Your Honor somewhat articulated, it's our position that if the state affects his tax's credibility on that, I should be able to get that into evidence. It was our position that since they're attacking his credibility in general, anytime I can have his credibility supported on relevant matters, I should be allowed to do so. Your Honor gave the ruling that Your Honor articulated.
Right. And the attorneys do have the ability to rehabilitate the credibility of their witnesses. I just put limits on the extent that we were going to go into it. That's largely how I arrived at my ruling. I'll also note too that we've had a number of other sidebars where we didn't make records. Everybody has the opportunity to make a record if they feel one is necessary. It's been my recollection that most of these substantive rulings have had records made in close proximity to the time of the sidebars. Others, I may have made rulings on form questions, foundation questions, given the attorney's direction to move in a different direction or approach a problem from a certain perspective. I don't think they were substantive in nature. It was more technical. I think some of the other sidebars had to do with the attorneys putting me on notice about things that are likely to occur or may happen. But I don't remember any other sidebars that involved the inclusion or exclusion of meaningful substantive evidence over the objection of one of the parties. Anybody remembers something that they want to make a record of, you have an open invitation to do so. I also want to circle back to exhibit number 24. Yesterday there was a request to seal a trial exhibit. Neither of the attorneys have provided me with any law authorizing it. And unless you do so now, I conclude that you still do not have supporting authority. As a judge, I
believe yesterday I articulated, I think exhibit number 24, I would just note chapter 950. I appreciate it's probably not my space to make that argument, but I will nevertheless. And chapter 950 involves the dignity of human beings, in particular victims. And in my opinion, the photos I think we're talking about the photos.
Yes.
Right? Those photos being made public is contrary to respecting the dignity of those people that have that right.
I understand the thought and the sentiment. In a way, as a human being, I agree. However, as a judge, I have to follow the law when it comes to sealing records. And judges are very restricted, at least in Wisconsin, about what records can be sealed from the public. And the authority is defined specifically by statute. Things like juvenile records, trade secrets, social security numbers, pre-sentence investigation reports, psychological studies. things like that are all defined in statute that a judge either is permitted to or is required to seal. Judges do not have broad authority to seal records that the judge thinks would be appropriate or to protect the interests of individuals, unfortunately. So because this is a trial exhibit, it's been received into evidence, because this is a public trial that does not involve a enumerated statutory basis for sealing, I don't have the authority to do so, even though I may prefer to do so. I simply just don't have the authority. So the request for sealing is denied on Exhibit 24. I provided the attorneys with a printed version of all of the proposed verdict forms. Did anybody have any objections?
No.
I don't.
Okay. So those will stand and be submitted to the jury. Is there anything else you want to address before we get back to the jury instructions? Okay, hearing none.
Actually, can we approach quick, Judge?
Yes. Have them printed. We left off at 1072, the attempted crimes for counts 2 through 5. Mr. Nelson, you had a lot of objections yesterday that applied to 1017. Those same objections would apply to 1072 because same issues exist in both instructions. So I've noted all of them for purposes of preserving the record. Are there other matters that you want to address in 1072?
Yes, Judge. In 1017 as well as in 1072 regarding the matter of second-degree reckless homicide on page 10 when you're talking about the homicide, and on page 20 when you're talking about the recklessly endangering safety, both in the second-degree matter. Both of them merely say the difference between first and second is the additional element. There is no mention in that discussion of second-degree reckless homicide, nor mention in the second-degree reckless endangering safety that it is the state's burden to prove beyond a reasonable doubt. I appreciate that it is in first-degree reckless homicide and it is in first-degree recklessly endangering safety. However, I think not including it in second to make sure and clear that the burden is on the state is in direct contradiction to the state v. Austin 349 Wisconsin 2nd 744 case that we've been discussing. This mistake, error in the instructions that were included is, I think, exactly what Austin says on paragraph 7, mentioning the jury instructions in Austin. Said, however, there was no mention of the burden of proof relative to self-defense. It talks about that in the context of recklessly endangering safety. And then later on page 17, it talks about the standard instruction implies that the defendant must satisfy the jury that he is acting in self-defense. In doing so, the instruction removes the burden of proof from the state to show that the defendant was engaging in criminally reckless conduct. So I'd ask that on page 10 and on page 20 when discussing the second-degree reckless homicide and the second-degree recklessly endangering, that Your Honor add the words that I believe were added in other aspects, and that Mr. Miu was not acting lawfully in self-defense.
All right, the objections noted. I am declining the request for the modification. Again, this comes from the pattern standard language from the jury instruction book, authored by the jury instruction committee. It's a committee of multiple judges who have studied these issues and have vetted appropriate language. The self-defense language appears in connection with first-degree reckless homicide and first-degree recklessly endangering safety. The jury will be instructed that one is not engaging in criminal reckless conduct if they're acting in self-defense. When we get to the second-degree versions of those offenses, the instruction makes explicit reference back to the wording from the first-degree offense, but simply tells the jury that the absence of utter disregard for human life, but the instruction for the second-degree offenses instructs the jury that they do not have to find the utter disregard for human life. So it's incorporating by reference the first-degree language. I think it is adequate. I think it is accurate. The attorneys will have ample opportunity to argue the respective points, including the importance of the self-defense being disproved by the state beyond a reasonable doubt. What's next?
That was the only additional request after reviewing the instructions, Judge.
Okay, and then last night we went through all of the other instructions. I'll give again another open call to additional instructions that you think, additional removal of instructions. Is there any changes, objections, concerns that you have to the jury instructions as presented?
Judge, regarding the excuse portion, I agree you can take that out. I'm not going to argue that in any way of provocation. So it was one of the bracketed instructions. It's on page 3.
Yes.
It's a single sentence paragraph.
It is removed. Anything else from the state?
Not on jury instructions.
Mr. Nelson?
No, Judge.
Okay. So I'll have the instructions finalized. My intent is to read before you argue. I'll also have the instructions displayed on the monitors so the jury can follow along. The jury will be provided with a few copies of the printed instructions in the deliberation room for their reference. Mr. Anderson, at sidebar, you said you had a motion to make?
Yes, Judge, I have a motion to strike one of the jurors. It was brought to my attention yesterday that during portions of testimony yesterday, one of the jurors was sleeping for an extended period of time and to the point of nodding off and then jerking awake. Both sides have a right to a fair trial, which includes juries that are attentive. I'm looking at Wisconsin Supreme Court case, State v. Novi, 346 Wisconsin 2nd, 289. It could, if there's a conviction, the defense could also try to argue that it violated defendant's right to fair trial. So obviously we want jurors who are paying attention to the evidence. So it's a two-step inquiry. One, it's a fact determination whether the juror was actually inattentive to the point of potentially undermining the fairness of the trial. And two, whether there's this is the appellate review standard if there's prejudice as a result.
Which juror?
4021.
Judge, we don't agree. I'm not looking at them, so I don't agree with the factual basis.
Mr. Anderson, if you want to pursue the matter further, you'll have to provide a witness.
State calls Investigator Schultz.
Investigator, please stand, raise your right hand and be sworn.
Do you swear that the testimony you're about to give in this
I did. Please have a seat in the witness chair. Mr. Anderson.
You've already testified, but can you please state your first and last name?
John Schultz.
And were you present throughout testimony yesterday?
Yes, sir.
At portions of the trial, were you watching the jury?
I was.
Was there a specific point during trial period of time, I should say, where you noticed a concern about whether a juror was paying attention?
Yes.
What did you notice?
I observed one of the jurors with her head down and would startle up with her head on numerous occasions.
What kind of time period, if you can recall? Was it like 10-minute time period, half hour, longer?
About an hour.
And she was dozing off and appearing to start awake
Yes.
multiple times?
Yes.
And from reviewing our jury list in our office, we believe that to be juror 4021.
Correct.
Nothing else, Judge.
Mr. Nelson.
What time did this occur?
I can tell you during what portion of the trial, sir, but I don't recall the time. I apologize.
Just yesterday this happened and you don't know what time it was when it happened?
Correct. I can tell you the portion of the trial.
Let's start from there. During which witness?
Lieutenant Hart.
And during Lieutenant Hart's direct exam or cross exam?
It would have been during her direct exam.
And that was the before the video or after the video?
During the video.
So was it during the exam or during the playing of the video?
I apologize. I think I'm getting confused. It was during the playing of the video,
Was it at any time other than during the playing of the video?
not that I observed.
When you made these observations, you were sitting next to attorneys representing the state?
Yes.
Did you make note to them, pass a note, give an elbow, whisper in an ear?
No, I told them after or during a break.
So you made this observation while it was happening and you just, for lack of a better term, sat there and let it happen?
Yes,
Didn't bring it to the attorney's attention?
I did during the break.
When you say the break after the playing of the video?
I believe so, yes.
Was there a discussion about whether the state thought the juror was on the state side or the defense side?
No, sir.
What was that discussion? Who did you tell?
During the break, I just told the attorneys that I observed a juror who I believed was sleeping. But I noted that I believe she was sleeping and not just closing her eyes because of her head quickly coming up like you would when you startle from waking.
And did you, at the time you didn't, your estimate of the time is, fair to say, rough.
Yes, sir.
You, during the actual live testimony from Brandy Hart, you didn't make an observation of any of this, correct?
Yes, sir.
It was correct. It was only during the playing of the video.
Correct.
It was only during a portion of the playing of the video.
Correct.
And your observation was just as you said, she had her chin tilted forward towards her chest at a couple of times during the playing of the video.
Yes, sir. Her chin tilted, eyes closed, and then head would come up quickly.
And when her chin was down and her eyes would close, would that last for a moment or would that last for 10 minutes or you don't know?
I was not watching her over 10 minutes, so I would say a moment.
Okay. So her chin would go down for a brief moment and then she would bring her head right back up. That's what you observed.
Yes, sir.
You didn't look over and see her chin down with her eyes closed and then look over and see her chin down with her eyes closed and then look over and see her chin down with her eyes closed. Agreed?
Sorry, I think I'm getting confused. Yes, that is what I would see.
I'm trying to figure out this, whether or not you observed her chin down, eyes closed, and she stayed in that position for some continued period of time, or whether you observed her chin go down, there was a startled moment, her chin would come up, or whether you saw something else.
I understand what you're saying now. So I was intermittently looking over, and during that period of time, there was times where I would just see her chin down, eyes closed. I would look back and it would be that way, and then I would see her startle with her head up.
So you're not in a position to tell the court the length of time that you observed her to have her chin down with her eyes closed? Meaning,
Continuous? No, sir.
you don't know whether that was for 5 seconds, 10 seconds, 10 minutes, you can't say.
Correct.
You just essentially noticed it a couple of times.
Correct.
And by a couple, 2 to 3, is that fair?
I'd say 4 to 5.
And of those 4 to 5 times, half of them were you saw her with her chin down and she didn't make a response, and half of them were when she had her chin, you saw her make this, what you've called a startled reaction up.
Yes, sir.
Would that be a fair estimate?
That would be fair, yes.
And the times that you saw her with her chin down and eyes closed, it was again just a brief glance. You weren't dialed in, focusing on her. Agreed?
Yes,
You agree with that?
I do agree.
Nothing else?
Mr. Jamerson?
So the 4 or 5 times, is that when you saw the head jerk?
It was both. At times I would look over and she just chin down, eyes closed. And then I would look over again and I would see that and then see the head jerk.
And did you see that for what period of time approximately from when you first noticed that till the end? Was it half-hour period of time, 45 minutes, hour?
Approximately over an hour.
Were there, when you looked over, if you recall, was it one of those 2 states, or were there several times where you looked over and she did appear to be alert?
Those are the only times that I'd looked over.
So when you looked over during that period, it was either chin down or startling awake?
Yes,
Nothing else?
You said it was only during the playing of the video. Agreed?
yes,
You understand that the video was less than an hour, correct?
approximately an hour, yes, sir.
It's about 50 minutes.
Yes, sir.
So based upon that, you couldn't have been observing this for over an hour. Agreed?
I object that we played it for 56 minutes.
The record's,
56 minutes.
it wasn't over an hour. Agreed?
Yes, sir.
And you can't tell the judge during those 56 minutes when you made the first observation. Agreed?
Agreed.
So you don't know if it was 15 minutes into the video, 30 minutes into the video. You can't say.
I cannot give you an exact time, no, sir.
And all you do is, you said you saw it about this 4 or 5 times, correct?
Correct, yes, sir.
And you're not in a position to say whether her head was down for any continuous period of time. Agreed?
Agree.
That's all, Judge.
Thank you, Detective.
Thanks, Judge.
Down. Is there anything else you want to say in support of your motion?
Judge, the video is obviously very important for the state's case. It was only played once. Clearly, we don't have enough time to play it again in closing, given the length of it. That would be our entire closing argument. Both sides are entitled to a fair trial with an attentive jury. So I think I ask that the court strike Juror 4021 as one of the alternates.
Mr. Nelson?
I don't think they've established a factual basis that she was sleeping. I think that there's reason to believe, but I don't think that they've established a factual basis of that.
I tend to agree. There are some clues to suggest that the juror may have been nodding off, but there's certainly nothing conclusive, certainly nothing that would allow me to make such a significant finding. I'll say, for my part, I was scanning the juror from time to time during the playing of the video as well. And my eyes were not fixed on them the entire time, obviously, because I'm trying to pay attention to the video, but I also was watching the jurors. I did not notice anything that would suggest somebody was sleeping. I have a different perspective than others. I'm not saying mine's better, it's just different. I did notice a number of occasions where people were looking down because they were writing on their notes, or they were averting their eyes, but they weren't sleeping. So I just say that to point out that there can be other alternative explanations for certain observations. The other point too is that even if we did have a sleeping juror, and even if that juror slept the entire presentation of the jail interview, it is a recorded interview. And if that juror ends up being one of the 12, that juror has the ability to request to watch the video. So it's not like live testimony that is lost forever. This juror, if they make it to the deliberation room, has the ability to view the video again and take that into consideration as part of her deliberations. So for those reasons, the request is denied. Is there anything else?
No.
All right. Anything else from the defense?
Just like a break before we get into openings.
We will, yes. All right, let's take a short break. We will resume at 8:45.
Can we test the?
Two hearts inside your eyes, can you feel the rush?
Please be seated. All right, members of the jury, good morning. But I will read them aloud in case you prefer to listen. After that, Mr. Anderson will deliver the state's closing argument. We'll take about a 15-minute break, and then Mr. Trofasi will deliver Mr. Miu's closing argument, and then the state will have the opportunity for a brief rebuttal. After that, you'll begin your deliberations. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions,